Part 10, Realm and Commonwealth by Stephen Spiers. Copyright 2018. Extirpate 1A. To destroy completely, wipe out. B. To pull up by the root. 2A. To cut out by surgery. Extirpation. Complete excision or surgical destruction of a body part. This is followed by King Henry VIII sending letters to sheriffs throughout the realm, wherein they are given orders as to the peace of the realm. Peace is an important term here, and we will discuss war and peace later. 30 June 1541, 9:45, the peace of the realm. R.O. Circular letter to the Justices of the Peace, expressing surprise that notwithstanding sundry advertisements lately made to them to do their duties, things are not directed with any regard to the good monitions set forth for the advancement of justice, warns them of the danger they incur by this negligence, and commands them to have special regard to the following points. 1. The King, having expelled the usurped power of the Bishop of Rome, with all its branches and descendants, desires that privy maintainers of that papalistic faction be tried out, as the most cankered and venomous worms in the Commonwealth, enemies to God, and traitors. 2. Raisers and spreaders of bruits touching the King, his honour or surety, the state of the realm, or the mutation of any law or custom, are to be punished. 3. Sturdy vagabonds and valiant beggars are to be punished according to the late statute, the neglect of which has bred no small inconvenience, and to this end the watches, which, by statute, are kept from Ascension-tide to Michaelmas, shall this year be continued until Hallowtide. Those who resist any watch or other officer are to be punished, unlawful games suppressed, and every man encouraged to use the long bow as the law requires. FN 14. 4. The justices shall earnestly bend themselves to the advancement of justice between party and party, that good subjects may have the benefit of the laws and evildoers be punished. The King trusts that this gentle admonishment will stimulate them to atone for past reminiscences. But if any neglect it, the next advised shall be of so sharp a sort as shall bring with it a just punishment of those that shall be found offenders in this behalf. Draft pp.8. Again, we have the mention of the cutting of Rome off, this time with some very harsh words. The King, having expelled the usurped power of the Bishop of Rome, with all its branches and dependents, desires that privy maintainers of that papalistic faction be tried out, as the most cankered and venomous worms in the Commonwealth, enemies to God and traitors. During the settlement of the colonies in the continental land of Australis, British subjects still believed in the faith through the Church of England. Coats of arms was issued to the Holy See of Australia as a continent was growing. This followed with self-governance and the dividing of the colony into Victoria and Queensland. Out of the Church of England came the Anglican faith of Australia, slightly different in attitude to the British counterpart, and likely due to the remote location and the harsh climates in which the settlers began to live. The country had its own styles of language and began to have a culture of its own as Australia. As the Anglican faith grew, the Pope issued papal bulls in relation to the Anglican faith, which had centred itself into the Commonwealth of Australia by Constitution and its blessing under Almighty God. Born from the motherland as the son of the father, the Commonwealth of Australia inherited by Act of Settlement 1700 every birthright that Queen Victoria had left behind. A papal bull is a public decree, basis for law under the Catholic faith. Apostolicae Curae is the title of a papal bull issued in 1896 by Pope Leo XIII, declaring all Anglican ordinations to be absolutely null and utterly void. The Archbishops of Canterbury and York of the Church of England responded to the papal charges with the encyclical Spiers Officio in 1897. The Anglican Church of Australia has its Court of St James in King Street in Melbourne, Victoria. The faith of the Anglican Church by Australia by Constitution, Canons and Church Synod are born from the Church of England. Within the building are coats of arms relative to the Royal Arms and the City of Melbourne. We can see that in the Commonwealth of Australia, the faith of the motherland is carried on through the Anglican Church of Australia. We also took from the motherland the authorised King James Bible 1611 and the Common Book of Prayer 1549 as the basis for the structure of the realm. Although, as we have seen throughout this paper, what is not what it always seems. With very specific embargoes on usage, the declaration of diplomatic relations with the Catholic Holy See before Saturday 24th March 1973. Issued by the Department of Foreign Affairs, the diplomatic representative, as of the Catholic Church, would be known as an apostolic nunciature, and the Commonwealth would have embassy rights within the Holy See. This is unusual given that the Church of England wouldn't have anything to do with the Pope, and now we have the Anglican faith being disregarded, the faith of the motherland in the Church of England being disregarded, and diplomatic relations occurring with the Papal Holy See, including treaty between Rome and the Commonwealth of Australia as entities. This is interesting because we refer back to the fact that in New South Wales in 2009, the Catholic Church, or the Holy See, was found not to be a legal entity, putting it outside of the jurisdictions of the court. This is in direct contrast to the Anglican Church of Australia, which had registrations as a legal entity made in 1959. Treaties with Rome in 1973 introduced uniform civil procedures rules, which were finally introduced into all court systems throughout Australia and updated in around 2009 for most states. This puts the civil procedures that occur within courtrooms under coat of arms suspect to the realm of Queen Victoria and the stem of authority as shown on Old Parliament House into a realm of treason against the realm. Now we have law of the Papal Holy See, which was, in the words of Henry VIII, seen to be the most cankered and venomous worms in the Commonwealth of Australia. Not only have the Catholics, through treaty, seen the advent of civil procedure in your courtrooms, we have a situation wherein papal bulls against Anglican ordinations haven't been repealed by the Pope. We have a St. Edward's crown in an imperial crown realm as of the coronation of Queen Elizabeth II in the United Kingdom and Great Britain and Northern Ireland and Australia. With Acts Interpretation Acts 1966, reflecting United Kingdom of Great Britain and Ireland, along with other evidences of the use of royal arms, to that effect within the Commonwealth of Australia. Now we have the Anglican faith, deemed heresy by the Catholic Church, extirpated from the Church of England, staunchly kept at bay in reformations, and deemed not able to sit on the throne in the Act of Settlement 1700 after Oliver Cromwell, and the trials of the King Killers saw parliamentarians destroy the St. Edward's crown not only once but twice. Had the Gough Whitlam era government given way to a new formation of the country, changing the Parliament of the Commonwealth of Australia to the Australian government, and introduced a new realm, including oath of allegiance, parliamentary oath, oath of office, and the notification that would affect every level of government, the national anthem, style and title, the use of coat of arms, jurisdiction, and more. We now have been conned out of our birthright in the imperial crown of Queen Victoria into taking a pledge to some cankerous formation of the Whitlam-era government, in secret meetings with a queen whom brought a St. Edward's crown into the realm, leaving the imperial crown as trust territories to the United Nations. What we have here is very serious business, especially given the papal bull Apostolicae Curae deeming the very core faith of the Commonwealth of Australia to be heresy, and King Henry VIII being applauded for calling them venomous worms. Through Royal Styles and Titles 1973, under Royal Style Manual of Queen Elizabeth II, this newly changed Australia, with new Oath of Allegiance, is now issued with a new Great Seal, which, as we have already demonstrated, has been shown to be in use through Letters Patent 2008 under Queen Elizabeth II. We also see that this same seal has been given powers as a royal seal, as well under separate royal warrant related to the same seal. Department of Foreign Affairs, number M/58, date 24 March 1973. Embargo, not to be used in any form before midnight on Saturday, 24 March 1973. Diplomatic relations with the Vatican. The Minister for Foreign Affairs, Mr. Whitlam, announced today that Australia and the Holy See had agreed to enter into diplomatic relations and agreed to the following joint communique. Australia and the Holy See, wishing to promote mutual friendly relations, have decided to exchange diplomatic representations with the rank of embassy on the part of Australia and an apostolic nunciature on the part of the Holy See. Mr. Whitlam said the names of the respective heads of mission would be announced shortly, adding that the Australian ambassador to the Holy See would be accredited on a non-resident basis. Mr. Whitlam noted that Australia had become one of over 70 countries, of which 12 were members of the Commonwealth, which maintained diplomatic relations with the Holy See. In so doing, it joined 10 of the most influential and populous of its Asian neighbours, including Indonesia, India, Japan, Pakistan, and Thailand. The Holy See remains resident diplomatic representation in over 60 countries at the level of nuncio or pronuncio, equivalent to ambassador, as well as having observer status to some 12 international organisations, including the United Nations, the European Communities, and a number of the specialised agencies of the United Nations. Mr. Whitlam said he expected that the apostolic delegation in Sydney would, in due course, become an apostolic nuncio in Canberra. The minister said he had taken careful note of views put to him by individuals and organisations before a decision on this question had been made. He emphasised that the step was one of several actions which the government had taken to normalise its relations with other states and should be seen in this secular light. The nature of any exchanges between the two states would be that of normal diplomacy and would in no way provide privileged access by the Catholic Church to the Australian government. Commonwealth of Australia Gazette, number S181, 10 September 2008. Special Gazette 3. Oath of Allegiance. I, Quentin Alice Louise Bryce, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, so help me God. Signed, Quentin Bryce. Sworn, declared and subscribed by the above-named Quentin Alice Louise Bryce at Canberra in the Australian Capital Territory before me on 5 September 2008. Chief Justice of Australia. Commonwealth of Australia Gazette, number S179, Tuesday 9 September 2008. Published by the Commonwealth of Australia. Special. Signed Elizabeth R. Letters patent relating to the officer of Governor-General of the Commonwealth of Australia, given at our court at Balmoral Castle on 21 August 2008 by Her Majesty's Command. Signed, Prime Minister. Commonwealth of Australia Gazette, number S181, 10 September 2008. Special Gazette 3. Oath of Allegiance. I, Quentin Alice Louise Bryce, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors, according to law. So help me God. Signed, Quentin Bryce. Sworn, declared, and subscribed by the above-mentioned Quentin Alice Louise Bryce at Canberra in the Australian Capital Territory before me on 5 September 2008. Signed, Chief Justice of Australia. 4. Special Gazette, Commonwealth of Australia Gazette, number S181, 10 September 2008. Oath of Office. I, Quentin Alice Louise Bryce, do swear that I will well and truly serve Her Majesty Queen Elizabeth II, her heirs and successors according to law, in the office of Governor-General of the Commonwealth of Australia, and I will do right to all manner of people after the laws and usages of the Commonwealth of Australia, without fear or favour, affection or ill will. So help me God. Signed, Quentin Bryce. Sworn, declared, and subscribed by the above-named Quentin Alice Louise Bryce at Canberra in the Australian Capital Territory before me on 5 September 2008. Signed, Chief Justice of Australia. Her Excellency Miss Quentin Bryce AG, Governor-General of the Commonwealth of Australia. Mr. Stephen Gagler, SC, Solicitor General, 3 to 5 National Circuit, Barton, ACT 2600. 23 August 2010. Dear Solicitor General, matters have arisen which have given me considerable concern about the exercise of very important obligations of my office under the Constitution. It has been suggested in some quarters that the fact that my daughter is married to the Honourable Bill Shorten MP creates some sort of conflict of interest that might impugn my ability to carry out the functions of my office. The issue of integrity and trust in the office is obviously of the utmost importance, not only to me but to the Australian people. I am therefore seeking your urgent advice as to whether these circumstances create any constitutional or other legal impediment to the proper exercise of my functions, particularly in the current circumstances where the outcome of Saturday's election remains to be determined and may involve me as the Governor-General playing some role. Yours sincerely, Quentin Bryce, 28/8. Government House, Canberra, ACT 2600, Australia. Now we start to build a picture. We have to consider this is relative to warfare at its core, and that the Queen is the head of the United Kingdom of Great Britain and Northern Ireland through her role as Queen of Scotland, England, and Scotland having union of crowns that was never broken at Balfour Declarations 1926 and Imperial Conference 1926. This is reflected by King George V, Royal Style and Title 1927, where the United Kingdom of Great Britain and Ireland is renamed Great Britain, Ireland, and. What we notice here is the oath of allegiance and the oath of office of Quentin Bryce, former Governor-General of the Commonwealth of Australia, is something very unique. Here, instead of the oath that is pledged by immigrants coming into the Commonwealth of Australia entering citizenship, here we have an oath of allegiance similar to the former Constitution's oath laid out in the schedule to the Constitution at Clause 9 of the Commonwealth of Australia Constitution Act, July 1900, UK/PGA. We also make note that Quentin Bryce then follows with an oath of office. If we refer to the Oaths Act, New South Wales 1900 at section 11 and 14, we come to realise that an affirmation has no basis at law, and that without oath there is no office, and under the Oaths Act, New South Wales 1900, it gives direction to be removed from office immediately. The same could be said of the Promissory Oaths Act 1868 UK at Section 7, wherein it describes penalty for taking incorrect oath. We have now to consider what is oath of allegiance and what is treason. Let's go through this conundrum. Let's look at the oaths of Quentin Bryce in 2008, the oath of the Commonwealth of Australia Constitution, and the Oaths Act 1900 New South Wales, which holds an allegiance as a former colony is now turned state and writing legislation in accordance with that allegiance. I, Quentin Alice Louise Bryce, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, so help me God. Commonwealth of Australia Constitution, Schedule Oath. I, AB, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law, so help me God. Affirmation. I, AB, do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law. Note: the name of the King or Queen of the United Kingdom of Great Britain and Ireland, for the time being, is to be substituted from time to time. First thing we might assume is that the oath is correct, given it is the correct wording, and that may be true, and of the case of Quentin Bryce certainly is. Here we have an oath of allegiance to a monarch under the realms of God. The wording is exactly the same as what is in the schedule to the Constitution at Clause 9 of the Commonwealth of Australia Constitution Act, July 1900, UK/PGA. But we have learnt that there is a strange difference going on within the Commonwealth of Australia in relation to the display of royal arms throughout the Commonwealth, states and territories, especially within the court systems of the country, which are supposed to stem through Clause 5 of the Constitution, ensuring that state courts are in line with the judicial chapters of the Constitution. Now we have a whole new realm and commonwealth replicated out of the former. Not many would consider what a St. Edward's crown means in relation to the imperial crown. Anzac fought in war theatres to defend a realm in the imperial crown, so that the Commonwealth of Australia is a body of people could find not only defence, but a foundation in the will of God, the authorised King James Bible, as the royal law being the Scripture. When we look back, the oath of allegiance to Queen Victoria is linked to the imperial crown and style and title throughout Queen Victoria's reign, including that removing the House of Hanover showed linked to her coat of arms. That oath is to the realm tied by the authorised King James Bible at coronation to Queen Victoria, Edward VII, and George V, who all took the style and titles associated with the imperial crown. George V going so far as to renounce all other styles and title, including proposed future styles and titles. Now we have a queen by coronation to a different named kingdom, renamed out of the former, but also bringing with her a St. Edward's crown and differing coats of royal arms associated with that crown, a different realm, kingdom, and line of authority than the former. We reflect back at the changes that have occurred to allow this to happen, and whether we have abandoned the birthrights associated with the imperial crown and its legacy under Queen Victoria, and her royal arms still on display atop the old Parliament House in Canberra. Now let's quickly look at the Oaths Act 1900 New South Wales, and then reflect back on the Great Seal of the Commonwealth of Australia 1954, and its change to the Great Seal of Australia in 1973. Looking at the Oaths Act 1900 New South Wales Section 11, we can see that the oath of office is required to sit office. We have seen how this stems through Letters Patent 1900 from Queen Victoria to the Office of Governor-General and to all officers including the Prime Minister's office. We have a direct line of authority here to the Imperial Crown and United Kingdom of Great Britain and Ireland. We have demonstrated how this is the birthright. That was the realm that allowed the Commonwealth of Australia to be. Now we have a Governor-General taking an oath outside of that realm to Queen Elizabeth II, under the United Kingdom of Great Britain and Northern Ireland, issuing Letters Patent 1984, constituting the office of Governor-General and likely in the capacity of Queen of Australia under the realms of the St. Edward's Crown. It is interesting to note that at the time that Quentin Bryce was taking oath to a foreign realm, to the birthright left by Queen Victoria, in the same wording as the schedule to Constitution, immigrants to her Australia, to which she heads as Governor-General of Australia, is taking citizenship via a pledge to the body corporate in which she has become head. The Governor-General has taken an oath unto God in the realms of the Scriptures, yet the immigration is taking a pledge to a state body foregoing its rights to God, but pledging in the eyes of God. The people of the Commonwealth have been taken down a notch in the line of authority, and the servants of the people have become their masters. We can see by the Oaths Act 1900 New South Wales that the name of the sovereign is linked to the United Kingdom of Great Britain and Ireland. 6. Name of sovereign. The name of the sovereign of the United Kingdom of Great Britain and Ireland shall be substituted in the said form from time to time instead of the name of Her Majesty. We can also see that the oath of allegiance is to be taken by all persons liable to take said oath. 4. Oath of Allegiance. The form in the second schedule shall, subject to Section 6, be the form of oath of allegiance, taken by all persons liable to take the said oath. As we have explained through Letters Patent 1900 and the Office of Governor-General, the Office of Governor of New South Wales performs the same roles and oversees the oath of allegiance and subsequent oath of office, taken by those in public office throughout New South Wales, especially judges, magistrates, ministers, and other members of government and parliament. 8. Judges and justices of the peace. 1. The oath of allegiance and the judicial oath shall be tendered to and taken by judges of the Supreme Court and justices of the peace. 2. Repealed. 9. District Court judges and other judicial officers. 1. The oath of allegiance and the judicial oath shall be tendered to and taken by district court judges, magistrates, and other judicial officers who are required by order of the Governor to take the same. 2. Repealed. The Oaths Act 1900 New South Wales is important, as with the Oaths Act 1867 in use in Queensland. They are both define the oaths of allegiance to the realm, in particular of the Imperial Crown. Although the Oaths Act 1900 New South Wales is very specific on the penalties for not taking an oath, whether on purpose, by mistake, or incorrectly. It should go without saying that anyone not under oath of allegiance and oath of office is stripped of their office immediately, actually not being in office because of that oath. A promotion into office may not constitute the requirement to take an oath a second time. However, it is a requirement that an officer be under oath throughout New South Wales. This is an example by the state how important the oath of allegiance is. 11. Penalty on not taking required oath. 1. If any such officer, as foresaid liable to take any such oath, declines or neglects, when the same is duly tendered, to take such oath, the officer shall, if the officer has already entered on his or her office, vacate the same, and if the officer has not entered on the same, be disqualified from so doing. 2. But no person shall be compelled in respect of the same appointment to the same office to take such oath more than once. As we speak of Great Seals of the Commonwealth of Australia, in lacking to find King George VI for the Commonwealth, we have here the Great Seal of New South Wales under George VI displaying the royal arms and imperial crown. We tied the two together in that oath of allegiance is to the monarch of the realm, to which the Great Seal is to the same realm. A failure to be under oath of office stops anyone from being in office that is formed under the Great Seal of New South Wales. The interesting thing about the Oaths Act 1900 New South Wales is that it goes on to speak about affirmations, being in a different category to that of the oath of office. An affirmation is linked to the giving of evidence and allows anyone denying or incompetent to be able to make an oath to affirm their position. You can see at section 13(1) of the Oaths Act 1900 New South Wales that a declaration by affirmation is subject to the Evidence Act 1995. This allows someone without an oath of allegiance to give evidence at their word, rather than be in allegiance first to be able to speak. Part 3. Affirmations. 12. Affirmations. Subject to Section 13, when an oath is required to be taken, any person who objects to take an oath may, instead of taking such oath, make a solemn affirmation in the form of such oath, substituting the words solemnly, sincerely, and duly declare and affirm for the word swear, or for any other word or words to the like effect, and omitting the words so help me God, or any other word or words to the like effect. 13. Declaration or affirmation instead of oath. 1. Subject to the Evidence Act 1995, whenever any person, A, called as a witness in any court or before any judge or magistrate or other person authorized to administer an oath, whether in a civil or criminal proceeding, or B, having to make a statement in any information, complaint, or proceeding in any court or before any judge or magistrate, or C, required or desired to make an affidavit or deposition, objects to take an oath, or is reasonably objected to as incompetent to take an oath, or appears to such court or judge or magistrate or person so authorized incompetent to take an oath, the person may in lieu of such oath. 1. When so called as a witness, make a declaration in the form in the 6th schedule, or 2. In any other case, make a solemn affirmation in the form in the 7th schedule. 2. Whatsoever, having made such declaration or affirmation, wilfully gives any false evidence before such court, judge or magistrate, or person so authorized, or makes any false statement in such information, complaint, proceeding, affidavit, or deposition, knowing the same to be false, shall be deemed guilty of perjury if the evidence or statement, had it been an oath, would by law have been perjury. So now we have this second stream of authority stemming from a St. Edward's crown, observing the creation of a whole new world within a realm also under coronation to the Bible through the coronation process at Westminster Abbey in 1953. And with respect to New South Wales, we have a conflict to their Oaths Act 1900 New South Wales, wherein, as we have seen at Section 4, the oath of allegiance is to the realm associated with the United Kingdom of Great Britain and Ireland, wherein we have shown that is strictly linked to the imperial crown as detailed in Royal Style and Titles, in particular of 1917, wherein George V retains only the titles through Queen Victoria. With the display of the Great Seal of New South Wales under George VI, we can also show that Queen Victoria's legacy in the realms of the imperial crown are still sealed atop the royal arms, Yet, as we have discussed, there is a conflict of royal arms with the courtrooms of New South Wales courthouses. With Edward VII issue of the Great Seal of the Commonwealth of Australia, the process went reasonably smoothly. Queen Victoria had only passed away in 1900, and Edward VII did not receive Great Seal of the Realm, nor the Great Seal of the Commonwealth of Australia until 1903. The Great Seal shown in the postcard commemorating the US fleet visit in 1908 displayed the Great Seal of the Commonwealth of Australia under Edward VII, which corresponds to newspaper reports on the formation of the Great Seal of George V. The Great Seal of the Commonwealth of Australia under George V, shown below, can be found searching the National Archives online. As we showed earlier, it is similar to the Great Seal of Transvaal that existed before the Republic of South Africa. The small difference noted in the newspaper can be seen between the two Great Seals, especially on the Shield of Queensland. Going through the National Archives, Trove, and a few other sources, a Great Seal for George VI wasn't found. There is Government Gazette in relation to the destruction of the former seal and replacement by a new seal, as can be demonstrated in the Government Gazette at the coronation of Queen Elizabeth II, and the issue this time of two seals, a Great Seal of the Commonwealth and Seal of the Commonwealth. In previous royal warrants and respective proclamations, only Great Seals had been issued to Edward VII, George V, and George VI. Edward VIII had abdicated the throne in 1936 before any royal seal could be issued. This left a chain direct to George V, whose seal was preserved and is seen here in the National Archives. Before the 1973 issue of the Great Seal of Australia, instead of the Great Seal of the Commonwealth of Australia, it is important to note that the Gazette is headed Commonwealth of Australia Gazette under the 1912 issued coat of arms. The wording of the Great Seal is Great Seal of the Commonwealth in respect to our Commonwealth of Australia.